Okay, why don't we go ahead and get started? Again, thank you so much for joining us this afternoon. My name is Jamie Spiller Kaplan. I am one of the partners here at Chartwell. On behalf of Chartwell, we're very happy that you could join us on this webinar to receive an overview of Connecticut workers' compensation. It's my pleasure to introduce my colleague, Adam Harrison. Adam has been with our firm for a few years now and is an expert on Connecticut workers' compensation law, among other things. Adam will be doing the bulk of the presentation this afternoon. There should be a chat on all of your screens if you have any questions as we move forward. Please feel free to shoot any questions into that question box. I will be serving as the chat bot for the majority of this presentation. So if you have questions, I'll do my best to answer them in the chat. Anything that I think might be useful for the whole group, I will share with the class, so to speak. And if you have any questions following the presentation, please feel free to reach out to either myself or Adam Harrison. And we hope that this is just the beginning of a conversation with a lot of you who we may have not yet had the opportunity to meet. So with that said, I'll turn this over to Adam, and thank you so much for being here this afternoon.
Thanks, Jamie. Just going off that, so we actually will provide you following this webinar with some file materials as well as our contact information. So like Jamie said, if there are any questions, further concerns, feel free to reach out. So just to get started, as a general overview of the Workers' Compensation Act in Connecticut, it is codified under Title 31, Chapter 568. All employees who are both part and full-time are covered under the Act from their first date of their employment. Like most states, it's a no-fault system with the benefits being paid by the employer's workers' compensation insurance carrier. In Connecticut, it is an exclusive remedy for employees who are injured during the course and scope of their employment with a complying employer. To be a complying employer, the employer must provide proof of workers' compensation insurance to the Workers' Compensation Commissioner, which is essentially the venue for the workers' compensation court, if you will, in Connecticut. So they must either provide proof of workers' compensation insurance to that entity or provide proof to the Workers' Compensation Commissioner of solvency and financial ability to pay compensation directly to the injured employees and qualified beneficiaries. It is also the exclusive remedy for an injured employee against a fellow employee. There are a couple exceptions, one being where the fellow employee's action was willful or malicious, or the action was based on the fellow employee's negligent operation of a motor vehicle. Connecticut also does allow for third-party claims, where an injured employee can bring an action against a third party who may be liable for his or her injury. The employer has a couple options. They can either join the injured employee's civil suit, or they can pursue an action against the third party directly. In this case, the employer's damages are limited to any workers' compensation benefits paid to the injured employee, whether that's indemnity, medical benefits. The employer's damages in this case would be deducted from any amount recovered by the injured employee, either through judgment or settlement. With respect to wrongful discrimination and wrongful discharging rather, and wrongful discrimination, it is prohibited in Connecticut. So in other words, a employer is not allowed to fire an employee for filing a workers' compensation claim for an injury. If an employee thinks that they were wrongfully discharged or discriminated against, they can file a civil action against the employer in Superior Court, or alternatively, they can file a complaint with the Workers' Compensation Commission. If it is found that the injured employee was wrongfully discharged, discriminated against, then he or she could be entitled to payment of either back wages or job reinstatement. In this case, we see instances where, employees either are discharged, during a workers' compensation case for abandonment of job. Essentially they're injured, they go seek medical treatment, and they are never to be seen again. So they're discharged for abandonment of job, or they may be for some sort of misconduct. In these cases, we recommend that employers document everything as to the reasons of discharge, to combat against any wrongful discharge or discrimination.
And
There are.
if I can just pipe up for one quick second, just something to keep in mind, and a unique feature of the Connecticut system, as Adam pointed out, is that these wrongful termination cases can be filed within the Connecticut workers' compensation system. That's unique from most other states, where a wrongful termination case would have to be brought only in the Superior Court. So in practice, what that means is oftentimes there can be two companion cases that have the opportunity to be resolved together within the Connecticut workers' compensation system. With that, I'll turn it back to Adam, but just a unique feature to point out.
Thanks, Jamie. In Connecticut, there are 8 filing districts. As you can see on the PowerPoint, they're listed out. Hartford, Norwich, New Haven, Bridgeport, Waterbury, New Britain, Stamford, and Middletown. These filing districts are based on the town where the injury took place. So, an injury took place in the Hartford district. The filing district is Hartford. An employee is able to file for a change of venue if, say, they work in Hartford, so the filing district is Hartford, but they live in, say, New Britain. They can file for a change of venue to New Britain, so it's easier for them to access the courts. With respect to jurisdiction, the Connecticut courts have held that Connecticut does have an interest in awarding injured employees workers' compensation benefits if the injury occurred in Connecticut, if Connecticut is a place of the employment contract, or if Connecticut is a place of the employment relationship. Moving on to reporting and statute of limitations. Reporting by an employee who suffers an injury during the course and scope of his or her employment should immediately report the injury to their employer. If the injured employee fails to report the injury immediately, then the commissioner could reduce the award of compensation proportionally to any prejudice that he or she finds the employer had sustained by reason of the failure. The caveat there, though, is that the burden of proof rests on the employer to show prejudice. We do see in practice cases where an employee is injured. They said that they reported the injury to so and so. In actuality, they didn't. So that warrants a case. More investigation of a case to kind of backtrack who and when they reported the injury to. If they reported the injury, so on and so forth. So that does cause some issues in the event where the employee doesn't immediately, report the injury to the employer. The injured employee does have 1 year from the date of injury to provide notice to the employer. This notice is provided by filing a Form 30C, Notice of Claim for Compensation. If the injury is an occupational disease, however, the period of notice increases to 3 years. So a little bit more time for the employee to file a notice of claim for compensation for an occupational disease. A claim for benefits by a dependent or an estate must be brought within 2 years. Reporting by the employer. A employer is required to send the chairman of the Workers' Compensation Commission a report of all injuries sustained by employees in the course of their employment that result in incapacity for 1 day or more. in the event that it is found that the employer failed to report an injury sustained by the employee, the Workers' Compensation Commissioner may increase the award for compensation for the employee's injuries proportionate to the prejudice that the employee sustained due to the employer's failure to file. While in Connecticut, the employer is required to file a first report of injury for that result in incapacity for 1 day or more. And Jamie may have a differing opinion on this or back me up. I believe it's probably good practice to file a first report of injury regardless, just to document that an injury.
Absolutely. Always helps, never hurts.
Yeah. It's just, again, it documents that an injury did occur and that the employer is doing everything that they're supposed to do, and that they're in compliance with the Workers' Compensation Act. Now moving on to compensability. So first, starting with the definition of employee. So obviously, an employee, first, an injury is compensable if it's, an injury suffered during the course and scope of an employment by an employee. In Connecticut, the definition of an employee is codified under CGS 31-2759. An employee includes anyone who has entered into or works under any contract or service with an employer. The contract can be for the performance of duties within the state of Connecticut or outside of it. A person who is a sole proprietor of, or business partner who accepts the provisions of the Workers' Compensation Act. Anyone who is elected to serve as a member of the General Assembly of Connecticut, is a salaried officer or paid member of any police or fire department, is an elected or appointed official of any town, city, or borough of the state of Connecticut, or is a member of the armed forces of the state while in the performance of military duty, or is elected to serve as a probate judge. An employee in Connecticut does not include any person whom articles or materials are given to be treated in any way on premises not under the control of management of the person who gave them out. Typically, an example of this would be, say, an individual who goes to a job site, maybe an independent contractor who brings all their own, tools, materials, things like that. It does not include one whose employment is of a causal nature, or casual nature rather, and who is employed otherwise than for the purposes of the employer's trade or business. Does not include a member of the employer's family dwelling, or any person engaged in any type of service in or about a private dwelling, provided that he or she is not regularly employed by the owner or occupier for over 26 hours per week. It does not include, an employee does not include an employee of a corporation who is a corporate officer and who elects to be excluded from coverage of the Workers' Compensation Act. And lastly, it does not include any person who is not a resident of Connecticut, but is injured in Connecticut during the course of his or her employment, unless such person works for an employer who has a place of employment or a business facility in Connecticut, at which such person spends at least 50% of their time, or works for the employer pursuant to an employment contract to be performed primarily in the state of Connecticut. Moving on to the definition of personal injury. In Connecticut, a personal injury includes, in addition to accidental injury, that may be, definitely located as to the time and place where the accident occurred, an injury to an employee that is causally connected with the employee's employment and is the direct result of repetitive trauma or repetitive acts incident to such employment and occupational disease. So basically that means an injury can be, I was hurt on this day, I was, lifting a package and I injured my back, or it could also include repetitive trauma or repetitive acts. So a worker, suffers a back injury from repetitively lifting packages. over a course of time, that'll be considered a compensable injury in Connecticut. It also includes occupational disease. This is obviously a pretty hot button issue given COVID-19. In Connecticut, it does include any disease peculiar to the occupation in which the employee was engaged and due to causes in excess of the ordinary hazards of employment. Occupational disease also does include any disease due to or attributable to exposure to or contact with any radioactive material by an employee in the course of his or her employment. Getting to COVID-19, actually, in July of 2020.
Can I jump in for 1 second before you get there?
Sure.
Just worth pointing out with respect to the statute of limitations for occupational diseases, you have 3 years from the date that the employee first learns of the disease or learns of the causal connection. So that's important to note because it's not necessarily 3 years from the exposure. It's 3 years from having that knowledge. That can get pretty sticky in practice because certainly somebody can become aware of an occupational disease much longer than 3 years after the exact exposure. So just worth noting and pointing out. With that, let's dive into COVID-19, given how timely it is, unfortunately, right now.
Yeah. So in response to the COVID-19 pandemic, in July of 2020, Governor Lamont issued an executive order, Executive Order 7JJJ. This order created a rebuttable presumption of compensability for employees who missed a day or more of work between March 10th, 2020 and May 20th, 2020 due to a diagnosis of COVID-19 or due to symptoms that were diagnosed as COVID-19. With this, there is a couple caveats. So the employee, this provided that the employee at the direction of the employer worked outside the home at least one of the 14 days immediately preceding the date of injury and was not provided the option to actually work from home, like most of us have been. If the date of injury was more than 14 days after March 23rd, 2020, that such employee was deemed as essential. This, of course, includes frontline workers, transportation workers. I believe it did include grocery store workers. So people who essentially didn't have the option to work from home throughout the pandemic. That the contraction of COVID-19 was confirmed by a positive test within 3 weeks of the date of injury, and that such positive test was actually provided to the employer or their workers' compensation insurer. This presumption can only be rebutted if the employer or insurer can demonstrate by preponderance of the evidence that the employment was not the cause of his or her contraction of COVID-19. If the presumption does not apply, then an injured employee is not precluded from bringing a claim as otherwise provided under the Workers' Compensation Act. So it is. I personally have not dealt with many COVID claims under this rebuttable presumption. It's kind of a sticky situation, as you can imagine. With contact tracing, things like that, we would encourage employers to do the best they can to contact trace, do things like that, so they can attempt to rebut the presumption. But again, if the presumption does not apply, so if the injured worker is alleging that they contracted COVID, outside this time period, they are still able to bring a claim under the Workers' Compensation Act outside this presumption. Personal injury does not include several things. First, it does not include an injury to an employee that results from the employee's voluntary participation in any activity where the major purpose of which is social or recreational. This includes athletic events, parties, picnics, whether or not the employer pays for some or all of the costs of such activity. It does not include a mental or emotional impairment unless the impairment arises from a physical injury or occupational disease or in the case of a police officer who uses deadly force or who is subject to deadly force in the line of duty and thereafter suffers either from a mental or emotional impairment. It does not include a mental or emotional impairment resulting from a personnel action, which includes a transfer, a promotion, demotion, termination, things of that nature. Personal injury also does not include an injury that was caused by the willful and serious misconduct of the injured employee or caused by the employee's own intoxication. As discussed earlier, the injury does have to arise out of in the course of the employer's employment to be compensable. In Connecticut, this is defined statutorily under Connecticut General Statute 31-275-1. And it is described as an accidental injury happening to an employee or occupational disease of an employee originating while the employee has been engaged in the line of the employee's duty in the business or affairs of the employer, upon the employer's premises, or while engaged elsewhere upon the employer's business or affairs by the direction, express or implied, of the employer. A personal injury does not arise out of the course and scope of the employee's employment unless it is causally traceable to the employment either then through weakened resistance or lowered vitality. If the injury is sustained at the employee's residence, this includes the residential structure, so the home, garage, stairways, driveways, walkways, the yard. And while the employee is engaged in a preliminary act or acts in preparation for work, unless such act or acts are undertaken at the express direction or request of the employer. Furthermore, an injury, disability, or death due to the use of alcohol or drugs, as just mentioned, is not a compensable injury. The Connecticut courts have interpreted what exactly arises or what exactly arising out of in the course of his or her employment means. A couple examples, or their interpretation rather, of the statute. They have found that an injury is said to arise out of the employment when it occurs within the employment and is a result of a risk involved in the employment or incidental to it, or to the conditions under which it is required to be performed. They have further ruled that an injury occurs in the course of the employment when it takes place within the period of employment at the place where the employee may reasonably be, and while he or she is reasonably fulfilling the duties of the employment or doing something incidental to it. A couple examples of how the courts have ruled on this issue. There was an example back in 2007. The Compensation Review Board had a ruling. An employee was injured while walking around the employer's campus on her lunch break. The lower court, the trial commissioner, found that this injury was incidental to employment. It was appealed up to the Compensation Review Board, which reversed and indicated that there was no evidence provided that the employer obtained a benefit from the employee's activity, but rather the employee went for a walk for her own benefit. So she was on her lunch break. She was, walking around for her own, health and fitness, as opposed to performing a task that was for the benefit of the employer. Another example, an employee was injured while playing softball at a picnic for city employees. The lower court, the trial commissioner, found that the injury occurred while the employee was on the clock, and the employee's supervisor had recruited him to play, thus finding the injury compensable. The respondent appealed this ruling, and the Compensation Review Board affirmed the trial commissioner's award. Another big issue with whether an injury arises out of in the course of employment is whether an injury sustained either coming to or going from work, on a commute, whether that's compensable. That is known as the coming and going rule. In Connecticut, generally, an injury that is sustained on a public highway while going to or from work is ordinarily not compensable. However, the Connecticut courts have carved out a couple exceptions to this general rule. Four exactly. If the work requires the employee to travel on the highway, where the employer contracts to furnish or does furnish transportation to or from work for the employee, where by the terms of the employment, the employee is subject to emergency calls. And lastly, where the employee is injured while using the highway and doing something incidental to his regular employment for the joint benefit of himself or herself and his or her employer with the knowledge and approval of the employer. A couple examples how the Connecticut courts have ruled on this issue. One being when an employee sustained an injury while walking on a public highway from the employer's parking lot to her workplace. The lower court, the trial commissioner, found that the injury was compensable as the employee had completed the commute and was performing a necessary activity incident to her employment. The respondent appealed this ruling and argued that the injury was not compensable based off the coming and going rule. The Compensation Review Board affirmed the trial commissioner's award and held that a free parking lot constituted mutual benefit to the employer and employee. Another example is an employee was injured in a motorcycle accident on his trip home from work from the job site. The trial commissioner found that the injury did not occur in the course of his employment. The Compensation Review Board affirmed this ruling, indicating that the employer had no control over the employee's movements and did not affect the hazards of the employee's trip home from the job site. The Compensation Review Board further reasoned that none of the four exceptions, as previously outlined to the coming and going rule, had applied. So with the coming and going rule, it's the courts have really looked at whether the the task that the employee was undertaking at the time was for the mutual benefit of the employer. So that has a huge bearing on whether the coming and going rule will apply. So that's a defense to for a respondent to dispute an injury that had occurred either on a commute, going to or from work, or things of that nature. Moving on to acceptance or denial of a claim. As mentioned earlier, a employee must give notice of a claim to the employer on a Form 30C, notice of claim for compensation, within 1 year for an injury or within 3 years for an occupational disease. Once an employer receives a Form 30C, notice of claim for compensation, it does have 28 days to either commence payment of compensation or file a notice that the claim is being denied. They must do this on a Form 43 notification of denial. On this Form 43, the employer must specify the grounds on which the compensation is being contested, liability, causality, extent of disability, what facts warrant the denial. Failure of the employer to either pay or deny the claim within 28 days will result in the employer being conclusively presumed to have accepted the compensability of the alleged injury, illness, or death, and the loss of any right to contest the injured worker's right to receive compensation on any grounds. So, as you can see, once an employer does receive a Form 30C, they do have 28 days to either pay or deny. It is a relatively short time window. Once that 28 days, that time is run, they are conclusively presumed to have accepted the case, unless it can be shown that notice of the Form 30C wasn't perfected on the employer. It either was served at the wrong address, or it wasn't, it was never received by the employer, things of that nature. So it is a relatively tight window.
If I can jump in for 2 seconds, just two important things to note on this issue. One, when in doubt, be sure to file that Form 43. You can always accept compensability of a claim after the fact. And it's such an essential part of the claim process. If you're not sure, if you're running up against the timeline, you should, under all circumstances, file it. You can always accept later. And as a second point, one issue that we hear a lot from our insurance carrier clients is whether or not the employer's notice of a claim is imparted onto the insurer. And the answer is yes, yes, it is. So be sure that you're having those conversations with your insured entities, that the second that they receive notice of a claim, that they have a clear procedure for getting in touch with you, because their notice counts towards the insurance carrier.
Exactly. So as Jamie just mentioned, even if they receive a Form 30C, the employer receives a Form 30C, there's no real issue as to the injury, no real dispute. It's always better to just file a Form 43 rather, to preserve your rights and defenses moving forward. Again, you can always accept the case later on, but always a good idea to just file it, to get that on file. Now, while the employer would be conclusively presumed to have accepted the compensability of the alleged injury if they don't pay or deny the claim within 28 days. The employer can still contest the extent of the employee's injury if it files a Form 43 within 1 year of receiving the Form 30C. So, just because there's no defense against liability, it's still a good idea to get the Form 43 on file within 1 year, so you can contest the extent of the employee's injury down the road, the extent of their disability. Once a claim has become accepted in Connecticut, the employer and respondent is obligated to issue a voluntary agreement for the payment of indemnity and medical benefits to the employee. The voluntary agreement in Connecticut is simply just a mechanism that establishes liability for the injury and serves to confirm the average weekly wage and compensation rate. It's typically we see claims that have been accepted, that have been paid, but no voluntary agreement was ever issued. In Connecticut, it is the employer is required to issue a voluntary agreement to establish compensability for the claim, and again to serve as to confirm the average weekly wage and compensation rate. Once an employer decides to pick up a claim and start paying benefits, first, the indemnity rates in Connecticut are published every year on October 1st. The state minimum and maximum rates are also published yearly on October 1st. The compensation rate is based off the amount of dependents and filing status of the employee, and also their average weekly wage. In 2021, the current maximum rate is $1,373, with a minimum being the lesser of $274.50, or 75% of the employee's average weekly wage. In Connecticut, there is a waiting period. No compensation should be paid for any injury that does not incapacitate an employee for a period of more than 3 days from earning full wages at his or her employment. If the worker's incapacity does continue for a period of more than 3 days, but less than 7, then compensation shall begin at the expiration of the first 3 days of total or partial incapacity. If the incapacity occurs for more than 7 days, then compensation shall start from the date of injury. Just as an aside, the injured employee is entitled to full wages for the entire day of injury, and that day does not count as a day of incapacity. Average weekly wage in Connecticut is determined by dividing the employee's total wages during the 52-week period immediately preceding the week during which the employee was injured by the number of calendar weeks during which the employee was actually employed by the employer. In the case where the employee was employed for less than 2 weeks prior to being injured, then the employee's average weekly wage is the equivalent to the average weekly wage prevailing in the same or similar employment in the same locality at the date of injury, unless there was an agreement between the employer and the employee as to a certain hourly wage that the employee was going to be working in a certain number of hours that was agreed upon as well. In the case of concurrent wages, if the injured employee has worked for more than one employer as of the date of injury, and the average weekly wage received from the employer which the employee was injured are insufficient to obtain the state maximum weekly compensation rate prevailing as of the date of injury, then the injured employee's average weekly wages shall include those wages from the concurrent employers. So if they if they aren't able to get over that maximum weekly compensation rate threshold, then their concurrent wages should be taken into account at the time of their injury. Going off that, the employer in whose employ the injury occurred is still liable for all medical and hospital costs. However, as far as indemnity benefits, the second injury fund is established in Connecticut. The remaining portion of the applicable compensation rate shall be paid from the second injury fund upon submission to the treasurer by the employer or the employer's insurer of such vouchers and information as the treasurer may require. So while the employer in whose employ the injury occurred will remain liable for medical and hospital costs, the second injury fund will reimburse the employer for indemnity benefits that have been paid to the employer, depending on their proportionate share.
If I can jump in, just a cool function of this is they will also contribute to full and final stipulation settlements. So that's a thing to keep in mind when you're trying to price up and resolve claims. And they'll contribute, obviously not for medical, but for their proportionate share. In practice, if you cite them into a case, if you are handling an informal hearing or you instruct your counsel to do so, it's a nice opportunity.
And going off that, the second injury fund does have a 2-year limitation on payment reimbursements. So, it is smart to be timely on that, or otherwise the second injury fund, won't reimburse if it's past that 2-year time limitation. Temporary total disability in Connecticut, an eligible employee would be paid up to 75% of their after-tax average weekly wage based upon the wages earned by the injured worker prior to the injury, which is up to 52 weeks for the length of their disability. An employee could also be entitled to temporary partial disability benefits. There's a couple of different situations where this can occur. If the employee is released to return to work light duty with restrictions, but the employer is unable to accommodate the employee's restrictions, then the employee would be entitled to temporary partial disability benefits. Usually the employee is required to submit weekly job searches to be entitled to these benefits. However, due to the ongoing pandemic, the job search requirement has been suspended until further notice. At another circumstance where temporary partial disability, an employee could be entitled to temporary partial disability is at a lower paying job, so differential payments if the employee is able to return to work either for the employer whom he or she was injured or a different employer and is earning less money than prior to his or her injury, and the employee is entitled to 75% of the difference between the after-tax difference between the wages they are currently earning and their average weekly wage prior to the injury. When an employee is released for work with restrictions, the first attempt by the injured worker to be reemployed should be with the employer where the worker was injured. If suitable work is not available or the worker is unable to work due to his or her disability, then there's no hindrance on the employer to discharge a worker, assuming that there is no employment contract, CBA, or company policy. Temporary partial disability benefits are paid for a maximum of 520 weeks. Permanent partial disability, these benefits are paid to an injured employee who has suffered a permanent and partial loss of use of a body part as a result of their work-related injury. The benefit is based on the specific body part which was injured and the treating physician's determination of the percentage of that body part which is disabled. Under CGS 31-308, there's a list of body parts with a total number of weeks of compensation for each body part. This benefit's paid using the employee's basic compensation rate. For example, the dominant upper extremity is payable up to 208 weeks if an employee has a compensation rate of 500 and is found to have a 10% impairment. To the dominant right upper extremity, the employee is entitled to 20.8 weeks of benefits at a weekly rate of $500 or $10,400. These are payable on voluntary agreements as well, so similar to accepting a claim, establishing the compensability and compensation rate. These are also memorialized on voluntary agreements based off the percentage, the date of MMI, and the compensation rate. Permanent and total disability in Connecticut, there's enumerated injuries for permanent and total disability. They include total and permanent loss of sight of both eyes, or the reduction to 1/10 or less of normal vision, the loss of both feet at or above the ankle, the loss of both hands at or above the wrist, the loss of 1 foot at or above the ankle, and 1 hand at or above the wrist, and any injury resulting in permanent and complete paralysis of the legs or arms of 1 leg and 1 arm, and any injury resulting in incurable imbecility or mental illness. There are also opportunities or entitlements to disfigurement and scarring in Connecticut. These are discretionary and awarded by a commissioner based off certain factors such as the location of the scar disfigurement, the size of the scar, whether the scar or disfigurement caused a tonal or textural skin change. Now, an employee is entitled to these benefits for scarring to the face, head, neck, or any other area of the body that makes it difficult for the employee to obtain employment. These benefits can be requested no earlier than 1 year and no later than 2 years from the date of injury or surgery causing the disfigurement and or scar. And these benefits are paid using the employee's temporary total disability rate and are paid up to a maximum of 208 weeks. A injured employee is also entitled to medical benefits. The employer should provide a competent physician to attend to the injured employee and provide any medical or surgical aid that the physician deems reasonable and necessary. An insurer or respondent is able to contest whether a recommended treatment is reasonable and necessary and causally related to the work injury. In Connecticut, a injured employee does have a choice of physician. The employee can select who they want to treat with after the initial visits with the employer-designated medical practitioner. If the employer does not participate in a approved medical care plan, the employee is able to choose any medical practitioner who's licensed in the state of Connecticut. If the employer does participate in a managed care plan, then the employee must choose a physician from the list of doctors included in that plan. If the employee does choose a physician outside that plan, then the Workers' Compensation Commission could suspend the injured worker's rights to benefits. The injured employee is also able to change his or her physician in the event that he or she is dissatisfied with the treatment that's being rendered. To get a change of physician, the employee must either get a referral from their current physician or obtain approval from the respondent to change physicians, or write to the Workers' Compensation Commission requesting a change of physician. If the employee does not have a referral for a new physician or approval from the respondent or Workers' Compensation Commission, then they will be on the hook for that unauthorized medical treatment. The employee is also entitled to travel expenses and lost time reimbursement for medical treatment. So this includes mileage, if things like that. The employee is required to keep a record, keep the mileage going to and from the medical facilities, and then submit those to the insurer for reimbursement. The employer is also obligated to provide transportation for the injured employee if they don't have a private vehicle to do so. The employer is also obligated to pay for any lost time that was incurred by the employee to obtain medical treatment. So if they are able to work, they're working, they have to leave, work to go obtain medical treatment, then they are entitled to lost time reimbursement. They're also entitled to prescription reimbursement. Prescriptions written by the attending physician as part of medical treatment for a work-related injury or illness should be covered by the respondent. They're also entitled to vocational rehab if the employee cannot return to his or her usual work because of a significant permanent impairment. Then he or she may be entitled to vocational rehab benefits. These are actually paid for by the workers' compensation rehabilitation services. There are also death benefits and burial expenses. A surviving spouse or other eligible dependent may be entitled to burial expenses up to $4,000 and benefits equal to 75% of the deceased employee's after-tax average weekly wage. In the case of where a surviving spouse is the sole presumptive dependent, benefits are paid up until death or remarriage. For a dependent child, the benefits last until the dependent turns 18 years old or is found to be incapable for life of earning wages. Lastly, there are discretionary benefits. These benefits are granted by a workers' compensation commissioner after an injured employee has been paid all of their permanent partial disability benefits. An injured employee is required to request an informal hearing to determine whether the commissioner will grant these benefits. Discontinuance and reduction of benefits. Benefits are either reduced or discontinued pursuant to a Form 36. They cannot be reduced or discontinued absent the filing and approval of a Form 36, unless it's a case where the employee actually returned to work. In this instance, the insurer should still file the Form 36 to memorialize that payment was lawfully discontinued. The Form 36 needs to be sent via certified mail to the employee's attorney, and the workers' compensation commissioner. Typically, the employee does have 15 days upon receipt of the notice to object to a reduction or discontinuance and request a hearing on the matter. However, due to COVID-19, this deadline has been suspended until further notice. Some grounds for reduction of benefits: if the employee is found to have light duty restrictions by a treating physician or a impartial RME physician, independent physician rather. Some grounds for termination: if the employee is found to have a full duty work capacity, either by a treating physician or RME physician. A full duty return to work by the employee's treating physician will almost always be approved administratively. Typically, any full duty release by an RME physician will require a hearing unless no objection by the employee. If the employee is found to have light duty work restrictions and the employer offers a job to the employee within those restrictions, but the employee either refuses to perform the work or fails to respond to a light duty job offer, that is grounds for termination as well. But again, it needs to be filed on a Form 36 and approved by the workers' compensation commissioner. Failure to accept or refusal of reasonable medical care. If the employee is lacking in their medical treatment, they're not treating despite it being authorized by the respondent, then their compensation could be suspended during the period of such refusal or failure. Typically, these aren't in practice, at least in my experience, they are more a mechanism to spurn the employee back into treatment rather than to suspend or terminate their benefits outright. Another instance is if a employee fails to submit him or herself for a respondent's medical examination or commissioner's medical examination, then their compensation benefits may be suspended during that time of refusal or failure. The proceedings in Connecticut, we're running short on some time, so I'm going to do the best I can to get through the full presentation here. So there are 3 different proceedings in Connecticut, the first being the informal hearings process. These can be requested by either party if an issue cannot be resolved amicably, either on medical treatment, requesting medical treatment, indemnity benefits, settlement discussions, etc. These occur before an impartial workers' compensation commissioner. The party that requested the hearing must submit documentation to support their request, such as medical reports, test results, demands for settlement, things like that. The issues are discussed at the informal hearing amongst the parties, with the commissioner making recommendations as to how to resolve the disputed issue. If the parties are unable to reach a resolution after the informal hearing, typically the matter will proceed for further informal hearing before being sent to the next level, the pre-formal level. If the issue can't be resolved after a couple informal hearings, the claim will likely be sent to pre-formal hearing. If these, in practice, in my experience, these are more, they're not much different than informal hearings. They're typically used as a mechanism to pressure the parties to either act or resolve the issue, as opposed to, forward the matter to a formal hearing. A formal hearing is a full evidentiary hearing. So if the issue at dispute cannot be resolved either at the informal hearing level or pre-formal hearing level, it will get forwarded to a formal hearing level, which again is a full evidentiary hearing. Evidence is submitted, witnesses are produced, testimonies under oath, the proceedings are transcribed. These are very rare that cases reach this level in Connecticut. Typically the dispute is dealt with at the lower level. Following the full and formal hearing, the presiding commissioner will either render a finding in award or finding in dismissal. The commissioner has 120 days from the date of the formal hearing to render his or her decision, which is binding on all the parties. After the commissioner has rendered his decision following the formal hearing, either party can appeal the commissioner's finding to the Compensation Review Board. A party has 20 days to appeal the commissioner's decision. The Compensation Review Board will either affirm, modify, or reverse the lower court's finding. On appeal, new evidence or testimony typically is not allowed to be presented to the Compensation Review Board unless it's determined that such evidence or testimony is material. And there was good cause as to why this evidence wasn't presented at the formal hearing. Moving on to respondents' medical examinations and commissioners' medical exams. While the employee is receiving workers' compensation benefits, the employer is able to send him or her for a respondent's medical examination, an RME. The employee does have the right to have their own physician be present at the RME, although in practice, I don't believe that many employees do that. The employee, as mentioned previously, must submit to the examination or risk having his or her workers' compensation benefits suspended during the period of such refusal. The Workers' Compensation Commission allows a physician to charge up to $750 for a RME. They decided this on this flat fee to balance out the difference between some cases that require more of a time commitment as opposed to those that maybe do not. A commissioner's medical exam, these are usually requested when there are different opinions on an issue between the RME physician and the employee's treating physician, whether that's a requested surgery or type of treatment. Again, the employee must submit to the commissioner's medical exam or risk having his or her benefits suspended during a period of such refusal. And lastly, on to settlement. So in Connecticut, the only way to entirely close out a case is via full and final settlement. These must be approved by a commissioner, and again, it closes out the workers' compensation claim in its entirety. Acceptance of a settlement by an employee means that he or she is waiving their rights to a formal hearing or a trial, if you will. The employees give up their rights to any future medical, disability, or indemnity benefits, which he or she may be entitled in connection to the work injury. They also importantly give up their claim, any claim for wrongful termination when entering a full and final settlement. Once a full and final settlement is approved by a commissioner, employers, respondents typically have 20 days to issue payment to an employee pursuant to a full and final settlement agreement. Just as an aside, this deadline has been temporarily suspended due to COVID-19, but the expectation by the court is that payment will be issued as soon as possible. Lastly, as Jamie touched on, in cases where there is concurrent employment, the second injury fund is able to contribute to a settlement based on its proportionate responsibility relating to that concurrent employment. So that concludes our webinar. Just three minutes, just in the nick of time. As mentioned at the top of this webinar, if there are any other questions, concerns, follow-ups, please don't hesitate to reach out to Jamie or I. And again, we will be providing you with some file materials. We'll coordinate with our marketing department to get those out. This lecture was also recorded, so we'll have that as well. But I want to, thanks everyone for attending. On behalf of Chartwell, we really appreciate it. So.
Yep. Again, thank you so much. It was nice to see some familiar faces in the Q&A and in the chat box. Anything that we can do to provide you with more information or assistance after this, please feel free to reach out. Again, thank you so much for giving us your time this afternoon.
Thank you very much.
And if you had fun and want to know more about Massachusetts, feel free to join us for our companion presentation on March 31st.